Hey everybody, Graham here. Yesterday I went through Amber Heard's assignment of error document, and today I'm going to go through Johnny Depp's. And this should go a little quicker because there aren't as many attempts to assign errors. Let's dive in and take a look. So here we go. We got the document right here. Appellant John C. Depp II, Mr. Depp or plaintiff, by and through his undersigned counsel hereby submits the following assignments of error. Number 1. The trial court erred by denying 1. Mr. Depp's motion for summary judgment as to appellee Amber Laura Heard's, Ms. Heard's counterclaim, and Mr. Depp's motion to strike the evidence as to Ms. Heard's counterclaim. A. Mr. Waldman is an independent contractor, not an employee agent, and Mr. Depp is not liable for Mr. Waldman's allegedly tortious conduct as a matter of law. So what they're saying here is that when Adam Waldman said the things he said, he was not acting as Johnny's attorney in that sense. He was only giving his own personal comment on the case. That's debatable, but a valid point to raise, I guess. B, these statements, called the counterclaim statements, by non-party Adam Waldman that are the subject of Ms. Heard's counterclaim are not actionable statements sufficient to support a claim for defamation. C, Ms. Heard failed to present any clear and convincing evidence that Mr. Waldman made the counterclaim statements with actual malice. The actual malice standard is, an important one because if he actually believed what he was saying and didn't have any compelling reasons to believe that it was false, then it's not actual malice. So, moving on. Now we've got a bracketed thing, and I'm not quite sure what to make of this. In brackets, preserved, plaintiff's memoranda to sustain demur, plea, and bar to all counterclaims, which motion the parties argued before the trial court on October 16th, 2020, and the trial court denied on January 4th, 2021, with respect to the 3 statements that ultimately formed the basis for the counterclaim at trial. Plaintiff's memoranda in support of the motion for summary judgment regarding counterclaim, which motions the parties argued, and the trial court denied on March 24th, 2022, as further reflected in the trial court's order. Plaintiff's memorandum in support of motion to strike, which motion the trial court denied after argument on May 24th and May 26th. So they made motions to strike the counterclaims on the basis that there just wasn't any evidence. So that's, summary judgment, meaning that the judge would just declare that those claims have no merit. So that's what they're saying that the judge should have done and didn't do. Number 2, the trial court erred in refusing Mr. Depp's proposed jury instructions numbers 22, 23, and 24 as to whether Mr. Waldman was acting as an independent contractor when he made the counterclaim statements, in brackets, preserved, Depp's proposed jury instructions numbers 22 through 24, which the trial court denied on May 20th, 2022. So they're saying there that they should have included an instruction in the jury form to declare whether or not they thought Waldman was acting as an independent contractor or an employee at the time he made those statements. Number 3. The trial court erred in excluding from evidence the full unredacted versions of Mr. Depp's exhibit numbers 881A, B, and C, which are copies of the news articles in which the counterclaim statements appeared, instead of admitting only redacted versions that showed the counterclaim statements out of context. Preserved, Mr. Depp's exhibits numbers 881 A, B, and C, copies of which Ms. Heard attached to her counterclaim as exhibits F, G, and H, which plaintiff argued should be admitted in their entirety. So these are saying, it's basically just what it says, that they should have admitted the full article with the statements, not just the statements themselves, so that the jury could get the context around that. I think that's kind of a valid point, because context does matter. I think these are reasonably valid points. And they all kind of seem to center around whether or not Waldman was speaking in his capacity as Johnny's attorney, or if he was speaking in capacity as just someone involved with the case who has an opinion about it. My view on that is that the evidence at the trial, and particularly the evidence that's come out since the trial, not that you can't introduce new evidence in an appeal, but there does seem to be a reasonable basis to say that that what Amber and her friends did was a hoax. And that was the basis of the counterclaim, was that that's a defamatory statement, but the truth is a defense to defamation. So if they could establish that Waldman had legitimate reason to believe that it was a hoax, and that he was not acting as Johnny's attorney at the time, then they couldn't really find that claim to be actionable against Johnny. Maybe she could sue Waldman, but I don't know. In any case, it's kind of moot anyway. But anyway, so that's what Johnny's saying about his appeal. Now, I suspect that this appeal, this counterclaim, is a little bit pro forma. I don't know if Johnny put up the surety bond or not. He could certainly afford to do so, which would stop any collection efforts that Amber would try to make. Now, so the interesting thing about this is that Johnny won $10.3 million. Amber won $2 million. Now, most of us would probably just look at that and say, okay, Amber owes Johnny $8.3 million. But that's not really the way it works. The way it works is Amber owes Johnny $10 million and Johnny owes Amber $2 million. And they can both collect on that. And I doubt that Johnny wants to give Amber $2 million before the appeal and before he has an opportunity to collect anything from her. So I think that's largely what this is about. I don't know that this appeal is made with a serious expectation of winning anything. What I think would happen here is that I think both appeals are going to be denied. The judgment is going to be let stand, and that's it. And Amber's only real option after that would be to appeal to the Supreme Court. I don't know if she can appeal to the Supreme Court of Virginia or if she's appealing to the Supreme Court of the U.S. That's something a lawyer needs to answer. But regardless, I think whatever Supreme Court that she goes to is going to take one look at that and go, not interested. Because Supreme Courts really only tend to take on cases that are either egregious judicial misconduct all the way up the line, or questions that tend to resolve a conflict between different courts. So I don't know too much about state Supreme Courts, but I know that, like, for example, in the U.S. Supreme Court, if the Fifth Circuit rules one way and the Ninth Circuit rules another way on questions that are fairly similar, the Supreme Court will often take that sort of case so that they can decide which one is right so that it can be applied uniformly across the entire country. Not sure how that works at the state level, but I assume there's something similar there. But in any case, that is the document. We shall see what comes of these things. What I think is going to be interesting, much more interesting than these documents, are the documents that will be filed subsequent to this, which will argue these points as opposed to just, stating them. So I'm looking forward to that. I have no doubt that the wonderful Andrea Burkhart will make those available, as she has done with these documents and with all of the unsealed documents from the trial. Can't say enough good about Andrea and the service that she's done to the entire YouTube community by doing this for us. So, Andrea, if you ever chance upon this video, thank you very much. And I will talk to you guys in the next one. Have a good one. Hope you're having a great day. It's really, really rainy here today, but I'm going to try to make the best of it anyway, and I hope you do too. Graham out. Bye.